that there are breaches of the Constitution, and you'll be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respected the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy of gross violation of the Constitution or other written law that the Constitution prescribes. Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the Deputy President to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different countries. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations. Whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. My learned friend, Dave Wanjiru here, and myself had the privilege of arguing the Wabora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wabora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution. Or that they did. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against a governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's very weighty issues that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the president and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as the Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 1, Ground 8 of the impeachment motion, alleged that the Deputy President had violated that nullified law, warranting his removal from office. By impeaching the Deputy President on the basis of a section that had been nullified by this court, what Sigin knew was the National Assembly sending to the public who had elected the Deputy President of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, alike case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in Ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, your leadership, the Senate voted on that impeachment charge on the basis of a repealed section. And you find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in Ground 9, The National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, Sub-Article 5, is supposed to be under civilian oversight of the government.